one theme I really want to kind of drive home for all of us is this quote, which is not something I made up, but it's often spoken about in this field. You can have security without privacy, but you can't have privacy without security. So what does that mean? Well, think of some of these fair information principles and some of these state laws that we've just talked about over the past couple of hours. So one of the key ones, for example, in privacy, is that an individual data subject, an individual, has a right to know if their personally identifiable information is being used. They have a right to know how it's being used, and they have a right to correct it if the information is wrong. They might have a right to receive the information that someone holds about them. All of those are privacy principles. Well, you can have security without enacting any of those principles. You could use personal information and not tell people how you're using it. You could refuse to give it back once you have it. You could refuse to say how you're processing it. All of those would violate privacy principles, but you could still have security. You could encrypt it and keep it perfectly secure. So you can have security without privacy, but you can't have privacy without security, because if the information is not secure, and if a third party can access it in ways that they're not supposed to, and or it gets out in the wild, obviously that information is disclosed. So it's really important to keep those things together. Another thing I want to emphasize that kind of introduces this connection that I'm trying to make between cybersecurity and data privacy, which has been mentioned, I think, in both of the prior talks, is the CIA triad. So I love this concept of the CIA triad, partly because it sounds like, you know, it's something top secret, but it's unfortunately not the CIA in Washington, but it's still pretty interesting, I think. And so C is confidentiality, I is integrity, A is availability. So when we're thinking about data security and when we're thinking about how data security relates to privacy, we want to keep this triad in mind. So C, you only have security if you have the ability to keep the information that you want to keep secure confidential. If it's disclosed, it's in a way that you don't want it to be, it's not secure. But you want to have confidentiality, but you also want to have integrity. And what integrity means is that the data stays whole, it stays complete, it doesn't get corrupted, and it's, you know, usable in the form that it's meant to be usable in. If you have confidentiality, let's say through encryption, and you don't have a means of decrypting the data, then the data is effectively scrambled. You don't really have data integrity. And then the third piece is availability. The data has to be available to be used in the appropriate way in which it's meant to be used, or else it's not worth anything. So you can see how this, and the reason it's a triad, it's kind of often put on a triangle, is because all of these pieces, one flows into the other, flows into the other, flows back into the other. If you don't have data integrity, the data is fragmented and broken, it's not really available. You can't really use it. So all these things flow together. So the overall initial theme as we launch into this segment that I want to communicate, and it was important to me when we were designing this whole program for you for this whole week, that we emphasize this theme, because we often still are siloing security and privacy, but they really should go hand in hand. And increasingly, I think the compliance functions around cybersecurity and the compliance functions around privacy need to be related to each other, or at least better communicating with each other. As we mentioned, there's no comprehensive federal cybersecurity regulation, and that includes that there is no comprehensive federal data breach reporting law. Now, there has been a lot of, or many legislative proposals in Congress about the possibility of some kind of comprehensive cybersecurity regulation. And even more so, there have been proposals in Congress, some of which made some progress before getting stalled, about the possibility of comprehensive federal data breach reporting. And I think this is an area where a lot of people agree that it would make sense to, even if you otherwise sort of agree with the federalism, state experimentation kind of rationale in other areas, that you have, in every state, a different data breach reporting requirement. Every state has one now. And they do contain some common things, including the requirement to give notice, but they contain a lot of differences. They contain some differences as to what triggers notice. They contain some differences as to what notice should be given. They contain differences about whether law enforcement should be notified. They contain differences about how much time should go by. And they contain differences about whether there's a private cause of action. Most of them don't, and a few of them do. So it would make sense, I think a lot of people agree, to bring some national rationality to that, and to even have a sort of national clearinghouse kind of way of doing it. But we don't have it right now. And some of that is just I think, political inertia at the federal level. Some of it is some real disagreements, and there's two really prime areas, I think, of policy disagreement that have to get ironed out. So one is whether or to what extent a federal data breach notice law would preempt state law. And for those of you in the virtual room who aren't lawyers, federal law under the US Constitution is the supreme law of the land. But the question is whether a statute passed by Congress intends to or has the effect of displacing state law. There are lots of places where federal law is meant to supplement or coexist with or reinforce in some other way or sit side by side with state law. But there are other times, a good example of this is the Federal Food and Drug Act, where we say, no, there's got to be a national uniform standard for when a pharmaceutical product like a vaccine is approved as safe and effective. So federal law says state law is displaced, is preempted. So do we want to do that with federal data breach notification law? And there's debate about that. And on the one hand, it would not be very efficient not to, because then you'd have to comply with the federal law and all 50 states. On the other hand, some advocates of the state laws suggest that some of those nuances might be helpful in certain contexts. And the other big piece of debate has been, should there be a private cause of action? So kind of as we discussed with some of the state privacy laws, for example, should it be the case that a failure to report or a failure to timely report or a failure to completely report, whatever it might be, gives an individual who did not receive proper notice a right to sue, which would open the door to class action litigation, or not? And that's a real substantive policy difference. Many, not surprisingly, many business groups don't want that. Many consumer advocacy groups do. There's a question in the Q&A. Someone asked whether the National Council on Uniform State Laws has issued uniform laws on data breaches or data privacy. I don't believe they have. I do believe there has been some discussion and activity around what state laws could usefully contain. I know there's been a lot of discussion at the level of the associations of attorneys general of the various states about that sort of thing, because a piece, again, we'll sort of touch on a little bit later in the week. To the extent there are federal laws on privacy or the General Federal Trade Commission Act, you have enforcement at the federal level, often by the FTC. To the extent there are state laws about data privacy or security that have enforcement provisions, you often have enforcement by the state attorneys general and also under the sort of omnibus state consumer protection law. So there's a lot of discussion around coordination there, but I don't believe that there's sort of been a model act. I could be wrong, and I'll double check and let you know if I am wrong about that. But I do think actually there are, some of at the state level, there are some things that are viewed as sort of federalism type differences. In other words, some states have a state police or other agency that is strongly dedicated to cyber, and they want that agency notified when there's breaches that affect consumers in their state. Other states don't. Some states want to have a private cause of action, other states don't. And that's also one of the reasons I think it's difficult to get a uniform federal legislation together. Okay, the last piece I want to touch on for another 10 minutes or so is on consumer data breach litigation. So I've kind of walked us through what I would say is sort of regulatory theory themes, regulatory design themes. I'm a law professor. I have to throw theory in there somewhere. But it's practical because we have a practical problem. It affects individuals, it affects individual companies, it affects the whole economy. It cries out for some kind of regulation, but it involves this really crucial and dynamic sector that we want, the market to keep dynamic. So how do we do that, right? And we've talked about comprehensive legislation at the federal level, state legislation, private ordering. And another way you often think about this, and it's kind of in many ways the sort of last backstop, but in many areas it can become a really important piece of the overall puzzle, is private litigation. And so here we're talking about consumer data breach litigation. But if I can put it into a little different context for a second to just help you conceptualize it a little. So if you remember, or if you've read about, in several decades ago, more than several decades ago, we had all this litigation over asbestos. So they, in the 50s and 60s, they did a lot of construction with this wonder product, asbestos, that was stable and work in terms of its rigidity and so on, and that prevented fires. But unfortunately, they came to learn it causes various kinds of cancer. And so the kind of first wave of mass tort litigation in the 70s and 80s was over the production and use of asbestos. And then we had kind of in the late 80s, early 90s. And when I first started practicing law in the early 90s, I worked on some of these cases, which big pharmaceutical drugs. I worked many years ago on the kind of first wave of for pharmaceutical companies on the first wave of litigation over SSRI antidepressants. So a drug is approved by the FDA as safe and effective, reasonably safe and effective. That doesn't mean it's perfectly safe, and it doesn't mean it's perfectly effective. That's pretty much impossible. And all drugs have side effects. And so even in the best of cases, some people taking a drug aren't going to get better. And some people taking a drug are going to experience a bad side effect. And then in the worst of cases, there could be situations where the company didn't properly investigate a certain side effect, allegedly, or allegedly didn't disclose something or other things like that. So we want this first line of regulatory defense of the FDA, but we also have this kind of backstop where if something really goes wrong or allegedly goes wrong, there can be private litigation. And that litigation, because it affects lots of people, often ends up being mass tort and or class action litigation. And then it's happening on a large scale. And when it's happening on a large scale, very rarely do these cases go to trial. Most of the time, they'll either get dismissed at some point along the process of the case going through the courts, or if they don't get dismissed, they'll be settled. And when they're settled, they result in a class settlement, and the class settlement applies to every potential member of the class, even if you didn't participate personally in the lawsuit. I won't do it now since we're in the virtual room. If we're in the real room, I'd say, raise your hand if you've ever gotten a notice of a class settlement. And I'm sure just about everyone has. And you probably didn't even really read it, but maybe if you read it, you saw, well, I might get a coupon for, $3 off my next chicken sandwich at this restaurant or something like that. Because your individual injury is probably only worth, a few dollars, $10, $20. You wouldn't bring a case about it. But if you multiply that across thousands or tens of thousands or millions or tens of millions of consumers, there's a lot at stake. So we have kind of predictably, yeah, very good. So someone asked, do I see cybersecurity issues arising as mass torts or as class actions? Very different. Well, so here's the kind of difference that if you've been involved in these cases, and I would sort of lump when I think of mass tort litigation and the kinds of cases I had worked on when I worked on these sorts of cases years ago in practice. Very often what you have is maybe hundreds of individual cases across the country, and then a set of related class actions. And part of this, I worked on the defense side. If you're on the plaintiff side, you'd recognize there's a dynamic of plaintiffs' lawyers competing with each other for the best case, who gets to be the lead counsel, and so on. And some plaintiffs' lawyers want to bring individual cases. Some file individual cases just sort of, they might ordinarily handle auto accidents and they just happen to get this case. So those individual cases can be coordinated in what's called a multi-district litigation at the federal level. And that can be multiple, even hundreds or even thousands of individual cases being coordinated for certain purposes. And or there could be a class action, and or there could often be both. And then there are issues about how they relate. Okay. So what I'm talking about here primarily, and this is what I have observed so far, is for consumer data breaches. And as I said, most of the cases, not all, but most of the cases that have been brought have involved consumer credit data, payment card information, where at least for some of the plaintiffs, the information got out there and a fraudulent charge was made on the account. Now, again, if we were in the room, just in the interest of time, I won't ask people to comment or raise the virtual hand, but think about it for yourself for a second. Have you ever had a fraudulent charge on your credit card or debit card? And again, I'm probably would get at least 3/4 of the room say you have. And if you have, probably 99% of you would say, it was annoying. My bank called me, or my card company called me, said they noticed the charge. I said it wasn't mine, and they wiped the charge from my account. A few of you might say, I noticed it, and I called the bank, and they wiped the charge from my account. Maybe one of you, maybe not, might say, I didn't notice until months later. It became a big hassle. For most of us, the banks are pretty good at scouting anomalous charges, pretty good at contacting us, and they are required, partly, again, because of federal law, partly because of the requirements of the agreements within the card payment system to reimburse us for fraudulent charges. I always tell the story. I've had several of these. One that I had, my bank called me and said, we noticed a pattern of transactions at gas stations in California. Have you been traveling in California? And I had not. And sometimes a way that these cards, these fraudulent cards, get laundered is at places like gas stations that have old technology for reading the cards, and people buy food and other goods and gas. They also, so that was obvious. They also said, did you sign up for Match.com, this dating site? And I've been married for 30 years, happily married. It wasn't me. No, the hackers or the person laundering the card signed up for Match.com. And I was in the kind of awkward position of explaining to my wife that it wasn't me, it was Russian hackers, right, that signed up for Match.com. But despite that inconvenience, right, the charge is reversed. So this is what happens in most of these cases. There's a number of people that are named as plaintiffs in the suit who have had fraudulent charges, but the charge has been reimbursed. And then there's lots of people in the class whose information was part of the batch of credit card numbers, the millions of credit card numbers exfiltrated, but who never saw a fraudulent charge. And the question in those cases is there actually a harm? And in kind of technical legal doctrine, the way that gets played out is on this issue of standing. Now, if you're a lawyer and or one of my law students, you've had constitutional law, you've suffered through reading cases on standing. If you're not, the basic idea is this: our courts in the United States, our federal courts and our state courts, are designed not to give general advice, not to do general regulation, but to hear specific cases and controversies. That's the term in the Constitution about what the federal courts are supposed to do. So that means if you come before the court, you have to have grounds to stand before the court and plead some kind of claim. You have to have suffered some specific, identifiable kind of harm. Otherwise, you don't have a claim before the court. You might want to talk to your congressperson. You might have a general concern. You don't have a claim in the court. So if you haven't suffered a tangible injury, you don't have standing. And so there have been lots of cases, and I'll show you in a minute kind of some recent trends. And this is the first place the battle gets fought in consumer data breach cases. Has there been a tangible harm if people who had their card information used were reimbursed, no out-of-pocket loss, and or if some didn't even have their card number used yet? Some courts have said, no, there's not. There's no standing. Other courts have said, yeah, you've had time, you've had energy, you've had maybe anxiety, you need credit monitoring, other things like that. So I'm going to show you in a minute the issue about standing. There are also cases that get dismissed at the pleading stage on the merits. Now, again, this is sort of lawyer speak. If you're a lawyer, you'll recognize it. If not, a case gets filed in court, and then, the next thing that would happen over the course of a litigation, and this may take years depending on the case, is the parties develop and exchange information they have to develop and exchange. It's called discovery. So you might take depositions, you'll exchange documents, you'll have lots of arguments about all that sort of thing. The party can also, the defendant who's been sued, can also say, well, wait a minute, this lawsuit doesn't even if we exchanged all that document and all that information, there's a legal reason why there's no claim here. And so you can move to dismiss the case early on strictly legal grounds. And that's what happens in some of these cases. And we would call that a motion on the merits. So on the merits, before any information is exchanged, there are questions about, well, is there causation? I mean, yeah, there was a data breach. Yeah, this individual had a fraudulent charge on their card. Yes, their card was one of the cards that was, exfiltrated in the breach. But what kind of confidence do we have that those two things are connected? You might say, well, it's a pretty reasonable inference. You might also say, who knows? I mean, there's 100 other ways that person's credit card information could have gotten into the wrong hands, including another breach that we haven't even known about yet. So that can be kind of difficult. There are some other things, some of these claims, someone had mentioned, I think in some of the discussion earlier, is it like a negligence case? Well, a negligence case typically, traditionally, relates to an injury to the person or an injury to property. So if I'm in an auto accident, it's your fault, you were negligent, I break my arm, injury to my person. My car is damaged, injury to my property, and I have a negligence claim. Usually we say, if all I have is economic harm, all I've lost is some money, my person hasn't been injured and my tangible property hasn't been injured, that's not a tort claim. That's not a negligence claim. It's a contract claim, maybe. We have an agreement. And that's called the economic loss doctrine. And that applies widely differently in traditional negligence claims as well as in these cases. So for these and a number of other reasons, many cases don't make it past sort of the early pleading stage. But some cases do. Now, I'll just show you briefly here the question about standing has been hotly litigated. And for those of you who are lawyers might be particularly interested in this. I don't know that the Supreme Court is going to take this particular issue, but it potentially could. So just in the past 3 months, there's been a case in the 11th Circuit, one of the federal appeals courts, which has said there is no standing just from expropriation of a credit card number. And even if you voluntarily take time and effort to cancel your card and to get credit insurance, there's no standing. The Second Circuit, which is the federal appeals court that covers New York, has come up with a sort of nuanced test to say, well, has it been exposed? What action have you taken? Do we know if some portion of that data set has already been misused or not? How sensitive is the data? A sort of balance. And in the particular case before the court found that there was no standing. There are other circuit courts, other federal courts of appeals that have found there can be standing. One of the key cases was in the Seventh Circuit, which covers Illinois, including the Chicago area. There are other circuits that have said there's none. The law is a little bit all over the place. So these cases are still, working their way through the courts. All right, and just the last 5 minutes I have here, I want to, before I turn it back over to Kelly, those cases, and this is not unusual for class action litigation in general. There's motion practice, there's motions to dismiss. Some of the cases are dismissed, some are not. If the cases get through the motion to dismiss stage, they almost always settle. And so there have been data breach consumer class actions that have settled, and this is a project that I've been working on for the past year or two. So I have identified, I think, all of them, at least as many as I could find. So there have been 38 settlements of these cases. The way a class action settlement works is a court has to approve it. And so 32 of these have received final approval. Some are still pending. Only 2 has a federal court denied approval. And one of those, the Yahoo case, they revised the settlement and it was subsequently approved. So I won't go through all this in detail. You have it in the slides, but just to get a little bit of a feel, and particularly for our discussion of risk and the kind of risk that consumer class action litigation is. If you are caught up in this kind of litigation, you'll see the class size is often very large. So there are very large numbers of potential people involved. Usually if you settle the case, there's a fund that has to be set aside for certain reimbursements to consumers. And that can be, that's not enormous for a very large company like, say, Prudential, but it's big, and it's a big number for a lot of companies. Individuals can get some kind of award, and then you're going to have to pay for some kind of credit monitoring insurance. Now we can discuss, I'd be happy to discuss in Q&A if you want, whether this is really a value to consumers, but this is sort of what it costs. These cases take a while to resolve if they get through settlement. It's going to, it's a couple to a few years of litigation. If you settle it, you're going to have to pay if you're on the defense side, you're going to have to pay the plaintiff's counsel's attorney's fees. And that's what these numbers are. And of course, you're going to have to pay your own attorneys to litigate the case. So, in short, even though there are lots of legal issues around how and whether these cases can proceed, the threat of this litigation and the existence of this litigation is still a significant risk. The claims may well get dismissed, but it's going to be costly to defend that, even through dismissal and then subsequently through appeals. And if they're not dismissed, they're going to result probably in some kind of class settlement that's also going to be costly. Whether this represents the kind of regulatory backstop that we hope private litigation supplies in relation to other kinds of litigation, I don't know. I have a little bit of skepticism, even in the sort of classic scenario of something like pharmaceutical products. I have maybe personally a little more skepticism here. But certainly without the other layers of regulation, it makes it challenging.